With the signing of the National Defense Authorization Act into law, more Americans than ever before are wondering how the country could have descended so quickly into a police state. Far from a unique or isolated act, however, the NDAA is just the latest entry in a long list of steps toward the codification of outright martial law. This is the GRTV Backgrounder for Global Research TV. Each year, the United States Department of Defense's budget and expenditures are approved by Congress, which must pass a National Defense Authorization Act in order to fund the DoD. The most recent bill, however, the National Defense Authorization Act for fiscal year 2012, shocked many by containing an extraordinary provision allowing for the indefinite detention without trial of anyone even suspected of providing support to individuals or groups identified as terrorists. Although this represents little change from the US government's modus operandi in waging the so-called global war on terror, many were amazed to discover that this provision specifically applies to American citizens who can now be detained by American military personnel anywhere in the world, including on US soil, and held indefinitely without trial. Perhaps it is not surprising that President Obama chose New Year's Eve as the date to sign the NDAA, as the revelry of the holiday predictably distracted Americans from the event. Particularly remarkable is the fact that this legislation has been almost universally identified as an overt act of tyranny by commentators of all political stripes, perhaps most importantly from sources that have traditionally defended the actions of Obama and his administration.
The ACLU said that Mr. Obama's decision to sign the National Defense Authorization Act, or NDAA, including the controversial detainee provisions, would tarnish his presidency. Quote, President Obama's action is a blight on his legacy because he will forever be known as the president who signed indefinite detention without charge or trial into law.
I will choose in my administration not to indefinitely detain U.S. citizens. Meaning another administration can choose to do so, meaning that the bill says, yes, the president has the authority and the option of detaining U.S. citizens without a trial indefinitely. This is definitive. And it's not just my interpretation. It's not just Glenn Greenwald's interpretation. As we told you yesterday, the team of lawyers at the ACLU, whose job it is to protect our civil liberties, says that is definitely the correct interpretation, and it is hideous. Now today, more people piling on.
My understanding is that when Carl Levin thought, the chairman of the Senate Armed Services Committee, thought in the Senate that the provision for it being applicable to American citizens on American soil was stripped out, the White House had it put back in, which is just dumber than mud. I can't understand how we'd want to go back to Reconstruction days. I mean, that's the last time we destroyed posse comitatus.
But this is the White House that thinks that it's okay to assassinate U.S. citizens abroad without due process in the case of Anwar al-Awlaki. So why wouldn't they want that in? Because this is codifying powers that they've already determined they have.
It's very true.
Now, on the heels of the NDAA, a new bill is making its way through Congress. The Expatriation Act, which would make the controversy about the NDAA null and void by simply stripping Americans of their American citizenship should they be accused of associating with government-deemed terrorist organizations.
The bipartisan legislation I introduced this week calls for a pragmatic recognition that a person who is purposefully and materially supporting acts of terror against the United States is demonstrating that they have no intent in acting as a U.S. citizen.
Congressman, so to be clear, this is not for people suspected, obviously, that civil liberties still exist in this country. It's only upon one's conviction that they would lose their citizenship. They'd likely be spending a lot of time behind bars as well.
Well, there would have to be a complete investigation. There's a standard of clear and convincing evidence. But in the case of Mr. al-Awlaki in Yemen, he has made public statements that have been hostile to this country. He has participated in operational aspects of terror attacks on this country, involved with Major Hassan. Now, we may never get to a trial with him. He's operating overseas, but there would be an investigation conducted by the State Department to determine this individual is an enemy combatant, a belligerent, and that would be the standard.
What the outrage over the NDAA and now the Expatriation Act reveals, however, is not that Obama or the current members of the House are suddenly taking the American government in a startling new direction, but that they are in fact continuing to pursue a coordinated policy agenda that has persisted through administration after administration on both the left and right sides of the political aisle for decades. In 1864, during the American Civil War, Lambden P. Milligan and 4 others were sentenced to death by a military court after they were found guilty of planning to overthrow the state governments of Indiana, Michigan, and Ohio. The case reached the Supreme Court after the war ended, where it was found to be unconstitutional for U.S. citizens to be tried in military tribunals as long as civilian courts were operating. This precedent remained intact for almost a century, with the Posse Comitatus Act of 1878 further delineating the boundary between the military and civilians by barring U.S. military from engaging in civil police actions, except by act of Congress. In 1942, however, the Supreme Court ruled on Ex parte Quirin, a case involving the detention of 8 German saboteurs during World War II and their trial as civilians in a military tribunal. The court ruled that the 8 men, one of whom was a U.S. citizen, could be tried as unlawful combatants in the war, a status applying to civilians who engage in armed conflict during times of war. Unsurprisingly, it is this Ex parte Quirin decision, allowing for the military detention of civilians, not the Ex parte Milligan precedent, which both the Bush and Obama administrations have relied on to try to assert their authority to detain civilians as unlawful combatants in the so-called War on Terror. In the immediate wake of the 9/11 attacks, Congress passed an authorization for use of military force, which authorized the president to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks. Less than 2 months later, Bush invoked that authorization to issue a military order declaring that individuals detained in the War on Terror be tried in military tribunals. The administration immediately began applying this order to detainees in Afghanistan, regardless of affiliation. The practice of detaining these enemy combatants at Guantanamo Bay and other military detention centers has been challenged repeatedly in the courts. When the Supreme Court finally ruled in Hamdan v. Rumsfeld that the detainees could not be held as unlawful enemy combatants, but had to be held as prisoners of war in accordance with the Geneva Conventions, Congress passed the Military Commissions Act of 2006, specifically authorizing military commissions for the detainees. In 2008, the Supreme Court ruled that Guantanamo prisoners were entitled to the U.S. justice system, but in 2009, Obama Attorney General Holder and Solicitor General Kagan testified that they believed the government could detain combatants in accordance with the laws of war, thus sidestepping the issue of determining a prisoner's status or their right to trial. Now, the NDAA of 2012 seems to extend all of these precedents and provisions to U.S. citizens. This comes in addition to Peace Prize laureate Obama's stunning declaration that he has the right to kill American civilians anywhere in the world without so much as a trial. Perhaps most worryingly of all, when Obama expressed reservations about the NDAA, it was not because he, as a constitutional scholar, felt the idea of using the military to detain American citizens on American soil was an unconscionable abrogation of everything the U.S. Constitution and Bill of Rights stood for, but because he felt that the 2001 authorization for use of military force had already granted him this power as supposed commander-in-chief in the supposed War on Terror, which has never actually been declared. Now, many are asking what can be done to prevent this seemingly inevitable slide into overt military control over American citizens and others around the globe. One voice providing an answer to this question is Stuart Rhodes, a Yale Law graduate and constitutional law scholar who founded Oath Keepers, an organization dedicated to informing American police and military personnel about the nature of their oath to uphold the Constitution, and how that oath precludes them from participating in acts that clearly violate the Constitution. Stuart Rhodes appeared on Corbett Report Radio last week to talk about the history of the use of enemy combatant status as a legal smokescreen to violate the Bill of Rights, and how citizens can work to reverse the damage that has already been done by the passing of this legislation.
Well, ever since 9/11, it's been the same exact claim of power through both administrations. And that claim is that your citizenship is irrelevant, that they can apply the international laws of war to Americans precisely as they do to someone in Afghanistan or Iraq. No difference. The NSA spying on Americans without warrant was defended during the Bush administration as being the power of the commander-in-chief to surveil the battlefield, and America as a battlefield. Bush detained 2 American citizens, Jose Padilla and Yasser Hamdi, in both cases of military detention, no access to an attorney, no grand jury indictment, no civilian trial, nothing. And unfortunately, the Supreme Court upheld that in the Hamdi case in 2004, upheld the designation of an American citizen as an unlawful combatant under international laws of war, which is totally in violation of our Constitution. You go look at the Article 3 Treason Clause, and it's right there in the text of the Constitution itself, tells you exactly what must be done with an American who is accused of making war against the United States or being the enemy. It requires a trial for treason in front of a jury of their peers in a civilian court, and it requires 2 witnesses to the overt act or a confession in open court. So extra evidentiary burden was put in place by the founders because they knew that the accusation of treason was the most serious charge any government could use against citizens, and they knew that that charge was used to crush dissent and to crush political opponents of the rulers throughout history. And we've seen that since. And so what's happening now, that they're circumventing the Treason Clause, circumventing the entire Bill of Rights, and acting as the international law of war trumps the Constitution, trumps the Bill of Rights, and they can treat you just like you were a goat herder in Iraq. So a goat herder in Iraq who's accused of stealing his neighbor's goat, for example, will get, a normal Iraqi trial. But if the U.S. military thinks you're a supporter of the enemy or an insurgent, what happens to the goat herder? He gets picked up and taken to Guantanamo, no trial whatsoever. This statute that just went through, NDAA, says the exact same thing can be done to an American. Under the laws of war, indefinite detention without trial, or trial by military tribunal. That's the claim. And this latest thing with expatriation is simply one more piling on of another way to strip you of your rights. One thing the founders did not have was the ability to remove the king or remove the traitors in Parliament. We have the possibility of rooting them out. Electing Ron Paul, the presidency, rooting all the oath breakers out of Congress, we can do it. And the model for that, I encourage people to go look at, is what Jefferson and Madison did in reaction to the Alien and Sedition Acts in 1798. They did 2 things at the same time. They started a new political party to root the oath breakers out, and they also nullified. They went to the states and said, you must nullify. You must intercede on behalf of your citizens and declare this null and void and stand up for the Constitution. We did the 2 same things. Nullify, including the military nullifying, refusing to do this, including our sheriffs, all the veterans in the country, towns, counties, states have to nullify. And at the same time, we need to root these people out, a scorched earth policy towards anybody who voted for this. Alan West voted for this. He's got to go. And I don't care who they are or why they voted for it. They're either knowing traitors or they're useful idiots, and they got to go. By any means available that are lawful, root them out. If you do not root them out, if you do not turn the tide through the political process, you'll be left with nullification only, and then it's going to matter. Then it'll depend upon what the military does. Either the military does a mass nullification and refuses to do it and gives us more time to repair things, or they start following these orders and we're thrown into the same position as our forefathers were in 1775, having no choice but to fight back.
For more on this story and other breaking news and current events, please go to globalresearch.ca. For more research and analysis by James Corbett, please go to corbettreport.com.